Yeah.
Go ahead.
Thank you.
Please
Yeah.
introduce yourself
to
everybody.
Okay. I'm Trisha Friedeberg, and I'm an attorney partner at Kato Feeder and Suzuki, a probate law firm in San Francisco, and do a lot of probate cases and a lot of court confirmed sales because of it, and have had a number with Eddie, and those are the best ones because they go extra smooth and for reasons we'll talk about in our 5 things to avoid and be aware of. And thank you, Eddie, for inviting me today. This is great to be able to talk with everybody.
You're the authority that we want to speak to on this, because you are the guiding light that makes them smooth. So
thank you. You go through different problems and you remember how to do them better. So I'm gonna just go quickly through the 5 and then go through them in a little more depth, and then Eddie said we can have some time at the end in case there are any questions. So first is just knowing why you need court approval and how and what that is, and making sure you really do need it. Second mistake that often happens is overlooking or minimizing some special circumstances that can create challenges. The third is not using a realtor who's familiar with the probate process because it is so different.
Doesn't happen with us.
No, it doesn't. And then the fourth is not doing your homework on your particular county and court and what their special set of rules are. The last is not setting the expectations and kind of preparing whoever your audience is, whether it's a conservatee or beneficiaries of an estate or trust, and kind of giving them a good preparation for what's ahead in a court confirmed sale. So going back to the first, really important to know, do you really need court approval? And if so, why? Because that'll kind of dictate what's going to happen next. And if you don't need it, there's some other considerations of things you can do to go a smoother route. So a court confirmed sale is basically, there are times when the probate code, that's California's laws for anything to do with the probate court, that you have to confirm a sale before a judge. You can't just do a normal sale where you're signing a listing agreement and then accept an offer and you're just working with your realtor and title company and buyers. In a court confirmed sale, sometimes you need to, even before you can sign a listing agreement, file a petition with the court to get approval of that listing agreement. And even that can take, right now it's up to 4 months, which is crazy, but that's what the court's calendar is looking like for hearing dates. And so you get approval of that listing agreement, then you can sign it. You just mark it the way you normally would with a few little caveats. Needs to be a special listing agreement, which things like a probate real estate attorney or probate realtor knows, like Eddie, that they're right, totally different forms, right, Eddie?
Totally. And then how you put the signer on the form is very important, because they don't want to be liable for any stuff on a personal kind of level. It's just all on the authority given to them via the estate. So there is a lot of, I notice a lot of times we do get confusion over, because there is a lot of scenarios where court confirmation and court approval is it's kind of like optional or possible. How can you talk a little bit about that situation?
Yeah, absolutely. So just kind of a quick checklist as to when it's mandatory to do court approval sale and when it's optional. You have to do court approved sale anytime it's a conservatorship involved, a guardianship, or in certain probates where the court has only given limited authority to the executor administrator. So it's something called IAEA powers, Independent Administration Authority. If you have, thank you. Yes, I left out a word there. So if you have limited powers, you have to get court approval of the sale. If you have full authority, you don't have to. The other times that you have to is if the will or trust says you have to. The times where it's optional is when you're a trustee or an executor or administrator of a probate, but you might have concerns like maybe there's a beneficiary who's objecting strongly or a creditor, and you want that protection of the court blessing your sale so that a beneficiary or someone else can't say, oh, you didn't get the best price, or we, did something that they weren't happy with. So that's kind of the two options. In those circumstances where you're getting it, where fiduciary is getting it to protect themselves, understandably, there are other options you can think about. One is just sending a notice of proposed action in both probates or trusts that just tells everybody, here's what I'm going to do. These are the offers I'm thinking about, I'm going to take. And that's a way to give the beneficiaries a chance to object, but not have to go through the court thing. The other thing you can consider is maybe getting their consents, them signing a simple consent. But otherwise, on the ones you have to get court approval for, it means you accept your buyer, your attorney needs to file a petition with the court and get a hearing date. Those they set a little quicker. It's usually 3 weeks or so out. And even those, though, we're seeing a little longer lately, but and then you have a hearing where the judge is going to let anybody come off the street, in theory, and
basically do an
overbid.
auction process. And there is a lot of resistance sometimes if there is a choice between kind of full authority where you don't have to do it and going that route. When it's properly put together and properly kind of marketed and handled in the right way, the court confirmation can be a very good way to go. So it's not something to be afraid of or avoid it in the process. So for mistake number 2, what do we see most commonly here?
Yeah, and Eddie, would you say too, there are times when, to your point a moment ago, that it can generate more interest? Yes. Yeah, more interest or higher price and certain circumstances.
And a better price it can generate. And I think because a lot of the ways we kind of educate the buyers on the other end when they come in is that you're going to have 2 bites at this apple. And the first bite of the apple is the first round where we're looking for a buyer that we can go to court to get confirmation for that buyer. But in court, you will have the ability to have a second bite at that apple. And sometimes, especially sometimes we're dealing with properties that have not been very well maintained, or there was an older client who just hadn't the ability physically or mentally or financially to be able to keep up with the demands of owning a piece of real estate, and they've fallen kind of into disrepair and there are it actually is a way to kind of market a property like that where we're able to get the maximum exposure and maximize value.
Yep. And that's a perfect lead into the second mistake, because the other thing that is understandably that also happens a lot is just overlooking some special situation challenge with your particular property and not identifying it at the beginning. So that can be, like Eddie said, a lot of these have a lot of deferred maintenance that could have some major issues that need to be dealt with, which is challenging in a normal sale. But in a probate sale, there are a lot of times where we need to go in for prior court approval before you can even hire a contractor or a plumber or whatever to fix it, because there's certain dollar limits. So looking at what needs to be done. There could be a tenant in the property. Eddie and I have dealt with this. The tenant could be a beneficiary. It can get very messy. And you need to know at the outset, do you need a landlord-tenant attorney involved? And if so, you need to get court approval for that before you can do much. Is there a reverse mortgage? In which case you're going to have to be in constant communication with the reverse mortgage company. They're getting harder and harder.
And harder to deal
with.
Yeah.
Their leash is getting shorter on their giving you some leeway. So, that's key. Any mortgage, obviously, just being on top of that. Is there a lot of personal property in the house? That can be really hard, and a lot of notices have to go out on that. Is it unimproved land? There are a little bit of different rules for those. Or if the property is in a county that's different than where your probate cases.
On a recent one that we're co-doing, that I think the administrator was quite smart in, we wanted to get the property out in, you know, like now, rather than sitting around for another few months going through the inventory of the property. They did an inventory of the property. They determined that the entire value of all that inventory was X amount. And, you know, in trying to dispose or find owners or sell all of this stuff, the amount of time that it was going to take to do all of that financially was more detrimental to the value of the property than it was to actually get that stuff sold. So they gave a notice of abandonment on that stuff, and we were able to move forward. So which was I thought a great solution. So
I think it's just identifying it so you can talk it over with your realtor and your attorney in the beginning to figure out the most efficient way to go about it. One last one just to throw out is, if you have a beneficiary or a conservatee, if it's a conservatorship who is on public benefits, you want to identify that really early, because getting a lot of cash might change their public benefits. You need to consider a special needs trust and get another attorney involved possibly for that. So it's something to think about early. It takes a while.
To get all in the planning, getting it is sometimes just with the different circumstances, there can be, you know, a runway of 6 months or so of planning to be able to get it to the point where we can put it out to the world. So
exactly.
My favorite mistake number 3.
I say it's your least favorite. It's using a
What's
realtor.
my favorite, because I know what I'm doing.
Using a realtor who has never done a probate sale. These are challenging with the best people involved who know what they're doing, because there are so many things out of our control when the court is involved. But these are different forms, they are different rules, different timing, I'm sure different conversations that Eddie has with the buyers and the buyers' agents, because it moves at a different pace. And if you have a realtor who's never done one before, and then your attorney is needing to educate them about the process, and we're not the best people to educate a realtor either, we know the court side, it's going to make it more expensive. It's going to take longer. The court may be frustrated with you, the beneficiaries, and there are so many reasons that I'm sure Eddie can elaborate on from your perspective.
Well, I'm not going to get into horror stories of some of the stuff we've seen, but ultimately, I think the most important part of working with a realtor that understands the process is their ability to educate the buyers is really the key as far as what's going to happen on how that property will perform, because it is a confusing process for the consumer on the other side, and it is a little scary. Well, more than a little scary, it's very daunting for them. And you know, to the point that companies that certain companies like national companies like Redfin Online don't allow their agents to get involved in them, because they're just it's something that they don't kind of understand, and they don't know how to educate their clientele. So it is very important to be able to educate a buyer, and then kind of lead them to the process of having people understand what is expected of them, and the opportunity that is available to them, and how to show up for court, and how to perform.
Because realtor's ability to do that is what's going to get the best price for the estate, which is the fiduciary's job, right? And
exactly,
you know, buyers are having to put down 10% up front, but then they know they're going to go to basically an auction where they may not be the winning buyer, and they can't be bidding on other properties in the meantime, and that can take months. So having a realtor who can ease those concerns and answer those questions gets buyers not to back away just because it's a court confirmed sale, which is key. And then also, you know, there's special or different liabilities that you as a fiduciary take on, right? That you don't know this property, so you don't know what's wrong with it. And the realtor can, who's savvy about probate sales, can make sure you're being protected in the best way through that.
Totally.
The other,
so number 4, item number 4, as far as to avoid.
Yep. I think not doing your homework on your particular court for whichever county you're in. Each of the Bay Area counties, their probate courts each run differently. I mean, the probate code is kind of the overarching for the state, but then each county has their own, what are called local rules. And I would say to fiduciaries and realtors, I always say this when we're dealing with a new case, is go to that county's website, wherever your property is located, your case is located, and look for the local rules and just Google or do a search for sale, real estate sale, whatever, and read that section, because they all have a little different nuance, and it's good to just be familiar. Now that all the counties in the Bay Area are still doing Zoom court, you can also just watch a sale hearing ahead of yours. So it just eliminates that unknown, and you can just kind of see the process and the judges and how it works.
We actually get buyers to do that. That's one of the ways we get buyers to feel comfortable is to do that.
That's a great idea.
I have to say too, in the beginning, I found the Zoom courts quite difficult because people wouldn't be on mute, and it was kind of chaos getting everybody registered. But the court clerks, they've gotten really good at this. Like they're really good at it, and it's very efficient, and it's quite easy now. You can log in, and we don't have to go down to the courthouse, and so it's and in a lot of ways for us on the sale end, it has made it a bit easier to get people to show up, for
more buyers, maybe overbidders,
more buyers to show up for the actual court confirmation and the second bite at the apple. So I do really like the Zoom hearings. So
absolutely. I think it's been that's been a real positive thing in that regard. And along with that, though, I think that's why it's important to talk to your attorney and know what the local rules are in terms of Zoom, because they're changing constantly. Like San Francisco just changed their Zoom link a couple of weeks ago. So just knowing you have the current information, because that can be the barrier to a buyer overbidder being there or not. And then just look at logistical things like, you do have a winning overbidder who's going to be the ultimate buyer. They need to get you a check immediately. So talking with your attorney and your realtor before the hearing about how are you going to do that? Are you going to meet at the courthouse? Are you going to take it to the title company? Just talking through those things. Because a lot of those little things can be things that trip it up. Then
that reminds me to go back to mistake number 3, just to get one of the things that we have found successful on the real estate end of it is a program that we use to share information on the property, the documented information like reports and that kind of stuff. We make every buyer sign up for that information, and then we're able to use that program to communicate directly with all of the buyers. So we've had instances on our own cases where 24 hours before the hearing, there's a very important announcement that we have to make everybody aware of, because we, like a new disclosure or something like that. So we don't want to postpone the hearing. And how can we show that we've actually notified everybody of this? And that a program that we use for that has been a lifesaver in that regard.
That has been really helpful. It's really important because you're dealing with last minutes, and just you want as many people there as possible who are going to overbid. And then the last one is just kind of, for all these reasons we've talked about, it's a huge mistake to not set the expectations of your audience, right? Whether it be a conservatee, if they're communicating with you and it's their home, this is a really emotional thing. And if it's beneficiaries of a trust or a probate estate, your realtor, if they're not, familiar with this process, because this just moves very differently, and court involvement means that no one can control the timing the way you can in a typical sale because of all these hearing dates and notices that have to go out. There are things that just can't be avoided. So, just kind of knowing at the outset, maybe preparing yourself to, as a fiduciary, that this is going to go the way it's going to go in terms of timing. And just have to, be prepared, and, be prepared to, if this money is needed to sustain a conservatee or something, that this can take a little while. Preparing, a lot of times, I'm sure Eddie can speak to this better, but the buyer's attorneys are not understanding the commission splits are very different, right? And just letting them know in the beginning so that no one's shocked and upset at the end, which I've seen happen from a realtor who doesn't know about probate sales. Triple checking things like, this is kind of a different point, but the vesting title, right? If someone's taking it as a husband and wife, they're taking it as joint tenancy, it's tenants in common, whatever, like things like that. If the buyer's agents and your agent aren't really all on the same page with this, that can cause all kinds of problems where the sale can't close.
All kinds of problems.
Right?
Yeah, because the paperwork has to match, right? The court order, and we're very clear with people in this regard, especially on the first bite of the apple, that when that offer is, and we're submitting, not just the offer is one thing, but when we're submitting the petition for the court hearing, that they state that the name that we have on that petition for the buyer is exactly how they want to take title. Because when the order is confirmed, or if they're successful in an overbidding scenario, the court papers will show that to be the buyer, and the recorded deed from the escrow company has to match exactly, or they can't close. So
and I've seen it where that hasn't happened, and that causes delays of months because, again, you're at the court's mercy of getting their revised order.
And in a world now where we're dealing with, the financial climate changing on a daily and weekly basis, if you run into a delay of a month, it's the difference between having a buyer and not having a buyer. And then we get into a lot of agents don't understand or realize either with the probate process, there is no liquidated damages, which is a very standard clause that all buyers have, where 3% of the purchase price is what they're risking in a sale if they don't perform. In a probate, it's kind of up to the judge. Like, you've 10% of your money in there, and if they want to go after you for more damages, they can. And we're in an environment now where if you have one deal fall through because of an error, the next buyer might be getting it for $50,000 less, and that could be a horrible situation for the first people in line. So, cool.
Exactly.
Awesome. Well, Trisha, this is amazing. If anybody, I'll open this up a little bit for any questions. If anyone has any questions, we're happy to answer them. And if not, no questions at all, that's totally fine too. So yes, Toby, how can I help?
So I'm a fiduciary, and it's very common argument among fiduciaries that you use a local realtor who knows about the schools and where you pick up coffee or whatever, versus a realtor who specializes in probate and trust and probate and trust sales, court involved sales. And so, they are. So anyhow, that's my question. Where do you fall on the two to get the best price?
So from my perspective, I think knowing the neighborhood and the schools and such is going to help you, potentially get the best marketing and such for that neighborhood. But
Right.
If you can't get through the barrier of the court process, that's not going to matter. And I have had a number of sales with really experienced probate realtors and a number with the other kind of thing you described.
Right.
And I can tell you, it doesn't go as fast. So if the market's declining, it's going to take longer. It gets much more expensive in attorney's fees. So any benefit that you may have gotten on a higher price is going to be offset. So I 1,000% say a probate realtor is key because, and for the reasons we said earlier too, and I think you Toby, you probably were thinking this already, but it's like if you can't get the buyers to the table, it doesn't matter. And there's so much nerves involved, understandably, for the buyers.
So I'm always, go ahead.
Well, just to throw in an answer from the real estate agent, they for agents are constantly, we always need to get ourselves up to speed on stuff, and the school part and where to go for coffee and what's cool about a neighborhood is it's super easy for us to kind of figure that out. And it's not a lot of agents that use that as their niche for marketing. Oh, I know this neighborhood, I'm the neighborhood specialist. They're very open to competition. They're very kind of vulnerable to competition because it's a very easy thing to compete with somebody on. So ultimately, really educating buyers on how the process works is really where the difference kind of comes down. That's really, because we find that that's the hardest part of the process, is taking the time to educate every buyer, because every buyer that calls has never dealt with it before. This is usually the first time that they're coming across, and there's many agents, when they don't really fully understand it themselves, the explanation they give is kind of not that great, and then everybody's kind of in this process a little confused. So that really is the kind of most important kind of factor there.
Yeah, it's a good question, Toby. It's the first thing that new clients ask in these processes. Yeah.
Mm-hmm.
Awesome. So any other questions?
So I'm always getting calls from realtors who say, oh, I've handled court sales. And I say, okay, how many? And the typical answer is 3, 5, 6. What is a good threshold?
Good. That's a great question. There's that whole expression of 10,000 hours to be an expert on something. So, ultimately anything that would be double digits where you get into 10 or more, I think is really, for me, would be the scenario. Because if you've gone through that many, now if it's 10 in 10 or 20 years, maybe not so much. If it's 10 in the last couple of years or a year or two, then that would be the place to be.
I think too, sometimes realtors will say they've done probate sales, but they're not court confirmed sales. You send out a notice, right? And that's a lot easier. That's more like a normal sale, but it's the court part that I think I would ask them as a fiduciary.
Yeah, no, go ahead. But the other way is just where the only difference on that sale that you mentioned, Trisha, is the notification of a exempt seller. So it's knowing how to use an extra piece of paperwork in the transaction.
Okay, and my last question is, I missed what the summary of what the first mistake was.
It was just being clear about, do you really need court confirmation and why do you need it? Because is it a conservatorship or a probate or a trust?
Great, thank you.
You're welcome.
Fantastic. problem. Trisha, if we're looking for you, how do we find you?
Well, at my law firm, but I don't. I have a very long last name for the email address. So maybe if it's on the, but I'm at
your last
computer.
name does show up on your
Okay, so
name tag right
yeah,
there on screen.
it's-
So
Oh, okay, thank you. It's Friedeberg at kfslaw.net.
Okay,
Perfect.
just a minute. What was the other half at, well, what, .net?
Oh, I'm sorry. So T Friedeberg, T Trisha, at KFS as in Sam law.net.
kfslaw.net. And we can be found at www.elevationrealestate.com.
And you're both out of San Francisco?
Yes.
Trisha's jurisdiction is probably larger
Whole Bay Area,
than
yeah.
the whole Bay Area. We're the immediate Bay Area. So Oakland, Berkeley, San Francisco, and the peninsula.
Okay. Well, thank you. I appreciate this.
Fantastic.
Nice to meet you, Toby.
Yeah.
Awesome. All right. Nobody else has been raising a hand. So I think this is it's been another wonderful second Tuesday. Thank you, Trisha. And you'll be back for more on other second Tuesdays in the future. So thank you all.
Thanks for inviting me.
Cheers.
Bye, everyone.
Awesome. Thank you. Bye-bye.